In a twist that has shocked a lot of people, Elon Musk has publicly criticised Nigel Farage, saying the Reform Party needs a new leader. Farage doesn't have what it takes. Now, of course, Nigel Farage has responded to this and said, well, this is a surprise. Elon is a remarkable individual, but on this, I'm afraid I disagree. My view remains that Tommy Robinson is not right for reform, and I never sell out my principles. Lee Anderson followed up and said, I wouldn't be here without Nigel, and Nigel is right. Over the next 4 years, Reform UK, led by Nigel, is going to fight for the heart and soul of our beautiful country. And that tweet goes on, of course. So in this video, this spat is obviously over Tommy Robinson. And that is further backed up by Elon Musk's posts, once again, free Tommy Robinson now. And that is further backed up by Elon Musk's other posts, once again, free Tommy Robinson now. And this one here, I know he's in prison for contempt of court, FFS. But there is no justification for such a long prison sentence or for solitary confinement. So in this video, I thought I'd do a little bit more about Tommy Robinson being held in contempt of court and sent to prison, and for so long, and his being held in solitary confinement, and for which that bit I will steal a short clip from my learned friend Alan Robertshaw of Art of Law, which I'll link in the description below. Yes, it rhymes. I will link that below. Fantastic video. I'll steal a snippet of it, but then you can go and watch the full thing yourself. But this is obviously to do with Tommy Robinson being held in contempt of court and sent to prison. Now, there's another twist to this, with the Solicitor General getting involved in the case itself, because that is relatively unusual. It's not entirely unheard of. There's been claims that this is politically motivated. Now, strictly speaking, it will be a legal involvement for the Solicitor General to get involved to make these contempt applications, and it will do so on that legal basis where there is significant public interest, which generally will outweigh the interests of private parties involved in the original case, and the need to bring these applications for contempt where they see that an individual has so flagrantly breached an order of the court, in this case an injunction. Now, this video is not designed to tell you to agree or disagree. This is to set out really what's happened here and how and why he's been committed to prison for so long, and how there is one way that Tommy Robinson can reduce the amount of time spent in prison. I'll come back to that in just a moment. Now, this is full of highlights because I've done several videos on this. The bits for this video are here, green and pink. This bit here where the judge, in respect of the admissions where Tommy Robinson through counsel admitted to contempt of court and confirmed that answer verbally to the judge. The judge said he breached the injunction by publishing a film that he'd made in which he'd repeated the allegations. He published the film on X social media account and by playing it at Trafalgar Square. He also repeated the allegations in published interviews. He did this over the period of February 23 to July 24. Some of the breaches occurred after the Solicitor General had brought the first contempt application, hence there were two applications so that they could all be heard together. That is also an aggravating factor, that some of those breaches were after the original application, because he would have had notice of that. I presume he would have had notice of that. The pink bit here, the judge says, there's a bit I've missed out here. The judge says nobody is above the law. Nobody can pick and choose which laws or injunctions they obey and which they do not. Even, and this is a really important point here, the judge says even if a person is convinced that an injunction was wrongly granted, or is contrary to their views, or is contrary to what they regard as the weight of the evidence, they must comply with the injunction unless or until it's discharged. They are not entitled to set themselves up as judge in their own cause and simply breach the injunction. Otherwise, the administration of justice and the rule of law would break down. And I'll read the next bit. The judge says, it is in the interests of the whole community that court injunctions are obeyed, so that the rights and freedoms that are enjoyed by individuals can be protected and enforced. And of course, one of the mechanisms for that is an injunction. Now, this also has an overlap with many other areas of law, one of which I spent my early practice in, which was family law. There are orders of the court in family cases which are routinely breached. I say routinely breached. In my experience, many people routinely breach family court orders. And I'll come back to those in a moment. For one client that came to me as a bit of a side story, the client rang me, and the very, very first thing they said is they've just come out of court. The other party has said they have no intention of complying with the order of the court. And they had a dispute with the lawyers as to whether there's anything they can do about that. And so that's why they came to me. So that's why I say routinely breached. Literally, people have walked out of court and said, oh, there's no way I'm following that order. because they disagree with it. And as the judge says here, no one is entitled to say that they disagree with the order and therefore they're not going to follow it. And so also in this case, coming to the amount of time in prison, ordinarily, in civil cases, we don't sort of punish people, but where there's an overlap here, where this is a contempt case, there is both a punitive and a coercive element to this sentence. So the judge had divided it up here, which then leads on to one aspect in which Tommy Robinson could reduce the amount of time he spends in prison. Allow me to explain. This is now the orange bit that I've highlighted here, aside from the costs underneath, which are £80,000. Now, under the punitive and coercive elements, the judge said, I divide the sanction into a punitive element to punish and a coercive element to persuade. The judge says the period of 14 months less 3 days that he'd already spent in custody is the punitive, the punishing element. The balance of 4 months is a coercive element. That means that 14 months less 3 days is intended to punish the breaches. The 4 months is intended to encourage and incentivize future compliance. The judge says it is open to the defendant, Tommy Robinson, to purge his contempt and to seek the remittal of 4 months of the order, which would result in early release. So you would take the what is 18 months less the 3 days. He'll ordinarily serve half, but the 4 months he could reduce that by indicating his willingness to comply and, as the judge put it here, to purge his contempt and to seek remittal of the 4 months of the order. So he could reduce it by 4 months by being cooperative. Now, is that unusual? Well, it is not entirely unusual, but let me give you an example. First of all, examples in which the Solicitor General has been involved, because there's been arguments that this has been political involvement. As I say, strictly speaking, it will be legal involvement where it's in the public interest and where the public interest of someone complying with orders outweighs the interests of individual parties, and therefore the Solicitor General brings the application for contempt rather than relying on individual parties. Because absent the involvement of the Solicitor General, it will be the responsibility of individual parties who have sought and obtained an injunction to enforce that and bring that to the court's attention to bring an application for contempt if they refuse to comply with the order. Another side story example. I've had what we call a third-party debt order against a bank. Long story short, my client won a case. They were owed money. The individual didn't pay. We know that they had money in a bank. We can get what we call a third-party debt order, because a third-party debt is when a bank has money that belongs to the other person and it's a third-party debt. And we can have a third-party debt order ordering that bank to pay the money over to my client because we won the case. In that situation, the bank just didn't pay the money. I think through an administrative cock-up, excuse the phrase, but I think somebody left, it wasn't taken over, a month or two went by, and they just refused or just failed to respond, and therefore we had no choice but to go down the line of a contempt application, to hold the board of directors in contempt. Sure enough, that was paid very quickly because none of them obviously wanted to be held in contempt. That's when individual parties have to bring the application or even threaten to bring the application, and suddenly they comply. Now, in the case where the Solicitor General gets involved, there are not many. Allow me to move this across so you can see it slightly better. This is a free database on Baileye where you can search by cases. These are with a very rudimentary search of Solicitor General and contempt. So these are the cases. So it says total results 19. So on a very simple search, there may be others where it's not mentioned, but it's likely these are the majority of them. These are cases where the Solicitor General has brought a case in contempt. And one such example, this is not a Solicitor General case, this is another contempt case. One such example of contempt was from the family court. Now, again, the bit in yellow highlight is the summary of the case here. This is an anonymized case because it's a family court case. MGJ is one parent or guardian. The judge said here is not bent on getting Mr. Evans sent to prison. What she wants is for him to stop distressing the children by taking them away from her care and control. MGJ seeks a finding to the criminal standard beyond a reasonable doubt that Mr. Evans is in breach of the orders which I have identified. The relevant orders encapsulated within a later order of District Judge Capstick from the 21st of August this year, to which a penal order is attached. Now, what that is when there's an order of the court and there's a penal order attached, the penal order says if you don't comply with this order, you could be committed to prison or have your assets seized and so on. It needs to have that penal order on it to be brought to court for a contempt application. That is something that I've seen absent in previous orders, and so you can't make an application for contempt if it's absent that penal order. And so in finding contempt in this case, the judge in this case in the family court for repeated breaches of this order, the judge said, therefore the sentence I pass is one of 9 months imprisonment immediate. So that was 9 months in the family court for repeated breaches there. And you can have a look and find other examples of people being committed to prison in other cases. Taking another case, for example, paragraphs 19 I'm reading from here, the judge says, for the finding the defendant made a covert audio recording of a substantive court hearing in adoption proceedings brought under the Adoption of Children Act. So this guy recorded the court proceedings, which is obviously contempt. I say obviously, you may not know, you do now. It's contempt to record the proceedings without permission, and you won't get permission. The courts record them themselves and get them transcribed and so on. If you want an official transcript, you can get it. You usually have to pay for it. The judge says here the sentence is one of 4 months imprisonment. Then says, for the finding that thereafter, within a few days of the court hearing, the defendant disposed of the recording and associated documents to another, gave them to someone else, with a view to their publication on YouTube, there'll be a sentence of 4 months imprisonment, which will be concurrent with making 4 months imprisonment in total. So recording the hearing without permission and giving that recording to someone else with a view to putting it on YouTube, they were sent to prison for 4 months. So this was a fairly isolated incident, but contempt nonetheless, and that was 4 months. So if you take that into account with the gravity, the number of contempt, this is actually not miles away from what you might expect. So 18 months sounds like quite a long time, but for the number of breaches, it appears really that the judge has done it in line with everything else. But now let's jump to the solitary confinement bit. Now I will link this video from my learned friend Alan Robert Shaw in the description below. Just a few seconds on this solitary bit here. Who is it that decides why it is and how long it can be for? I will steal this little clip from him, but do make sure you go and subscribe as a gratitude to Mr. Robert Shaw in the description below. Have a listen to this.
When you enter prison, the governor of their own volition, or the prison manager, if it's a private prison, they can put you in segregation for up to 72 hours. That's just done at an operational level, and that can be just something while they're assessing whether it's safe for you to go into sort of general population or anything like that. If they want to hold you for more than 72, if they want to keep you in for more than 72 hours, then it has to go before something called a segregation review board, and they will look at all the circumstances, and they can authorise segregation for up to 14 days, and they can keep renewing that. However, after 42 days, any further segregation, it must be approved by the Secretary of State for Justice. Now, in practice, it's not actually the relevant minister who decides each individual case. They are allowed to delegate, and in practice, the person who actually authorises the decision is either a senior manager in the prison group director's office, or if it's a private prison, the head of the privately managed prisons office. And they must reauthorise every 42 days. But there is actually no limit to how long you can actually be kept in segregation, so long as they do review every 72 days.
So I'd strongly encourage you to watch the full video. I will link this below. Fascinating video. That is just a minute or so of nearly 19 minutes worth of information on this from Alan Robert Shaw. Fascinating video. Please do go watch it. And so this video of mine is not to tell anybody what to think, and it's not to take sides at all, but also just to point that advocacy is an art where you will speak on someone's behalf, whether you agree with their point of view or not. And so you'll very often find barristers, advocates, whether it is professionally engaged or just on social media, will very often make a comment, make a point, argue for somebody, defend somebody, or even argue against somebody. Sometimes it is just to keep that conversation going, or it's just to offer another view. It is not always the case that an advocate will completely agree with one party or another. For example, I've spoken about Tommy Robinson a number of times on this channel. Do I agree with everything he's ever done? No. Does he agree with everything he's ever done? No. He's actually said to me that he doesn't agree with everything he's ever done. He says he knows he's done wrong things in the past and all that sort of stuff. So this is all really for the open discussion of views and ideas. Now, the issue that we have here with Tommy Robinson, first of all, with being held in solitary confinement, it's obviously been decided, it appears to have been decided that it is for his protection that is kept in solitary confinement. He would probably have some sort of say in it, but he will almost certainly have been asked for his views on that, but then ultimately they will take the decision with regard to his safety and everything else as to where he is. And they have to, of course, balance that with mental health and everything else. But more broadly, regarding his conduct and the breaches of that injunction, which came about by a civil case whereby Tommy Robinson tried to argue that it was true. And the judge said that based on the evidence, he did not accept that that was true. It's not the same thing as ruling categorically without any reasonable possible doubt that it's not true, but just on the evidence that was put before the court that it wasn't true. And I've done another video below where I've gone through that evidence in reasonable amount of detail, so I'm not going to say that again here. I will link that video below as well. Someone will remind me if I forget. But there's a great deal of detail through that judgment that the judge looked at the evidence brought before the court and didn't accept it, and for various reasons. Now, there are, of course, a lot of people that will probably say, go and watch the documentary, etc., but to a degree, and with respect, it doesn't really matter what it says. If it repeats the defamatory allegations, and the injunction said you must not repeat those allegations, then he will be in contempt of court by publishing it. Regardless if there's fresh evidence coming about, and etc., and then therefore published the allegations again, ultimately, the injunction is in place, and the court will say that there is a route of appeal. If you have fresh evidence, there is an ultimate end-of-line route of appeal if there's fresh evidence and there's good reason to hear it, etc. There are ways of appealing those decisions, and that is the route that the court would expect you to take, not simply by saying, well, I've now decided that there's another way of looking at this, therefore I'm going to repeat the allegations because I believe I've got fresh evidence, etc. Now, however strongly, and this is not to say that you're wrong, but however strongly that you believe that that should be the case, that is not the way that it works. That is not the way that the law works. For example, let's say you've got an order of the family court that one parent is not to remove the children from the care of the other or from school or whatever. That would be by way of a prohibited steps order, which again is just an order of the court that this parent must not do this thing, or must not remove from the jurisdiction is a common one, etc. Let's say that parent then realizes that the other parent has done something else wrong, or they've lied about something, and that parent, the subject of the order, then feels that, well, it's wrong now because the other parent has done something wrong, therefore I should be able to collect them from school. So long as that order is in place, they have to comply with it. Regardless if they disagree with it, regardless of fresh evidence, etc., what they need to do is go back to court and say, well, there's new evidence now. This person has lied. This is not true. This is wrong, etc. Give the court the opportunity to re-look at it and then say, well, actually, you're probably right. Now that you've given us this evidence, we agree with you. And discharge the order or vary the order and so on. That is really how it should be done. So hopefully that's given you some overview as to how these injunctions work, regardless of what people think about them, regardless of new evidence, regardless of views, etc. But it's interesting the different arguments that could be run in defamation cases. You can have the defense of the truth, but then you must prove that it was substantially true. But there is also the public interest element and the opinion element. So again, we've done videos on that in the past. But I hope you found that an interesting overview. Please do like the video and subscribe to the channel. I depend on you to help grow the channel. I am just about to hit 700,000 subscribers. So thank you so much for that. Thank you for watching, and I'll see you next time.